The views and opinions expressed on this program are those of the participants and do not reflect the views of BronxNet or the program underwriters.
BronxNet. Your voice, your views, your vision.
The third branch of our government, the judiciary, has been headlining the news for some time now, and justly so, with major decisions affecting marriage as well as your right to vote. But will the new rulings actually change American society? The answer is yes, and tonight we find out why. It's an important show, so stay right here because today's verdict starts right now. Welcome to today's verdict, the show that gives you your legal rights and options. I'm your host and trial attorney for the next 30 minutes, David Lesch. It's been a very busy term for our United States Supreme Court. In the last few weeks, the justices have handed out decisions that have impacted immigration, marriage rights, as well as your right to vote. In a 5-4 ruling, the Supreme Court struck down what some consider the heart of the 1965 Voting Rights Act, now allowing 9 states, mostly in the South, to change their election laws without advance approval from the federal government. This decision now allows states to implement laws that may actually affect voter turnout and ultimately an election. Needless to say, the White House was not pleased with the decision. Let's hear what Attorney General Eric Holder had to say after the decision was announced.
Now, like many others across the country, I am deeply disappointed with the court's decision in this matter. This decision represents a serious setback for voting rights and has the potential to negatively affect millions of Americans across the country. In the nearly half century since its initial passage in 1965, the Voting Rights Act has consistently enjoyed broad bipartisan support in Congress as well as the executive branch. After extensive hearings, Sections 4 and 5 of this important law were reauthorized, most recently in 2006, just 7 years ago, with the unanimous support of the United States Senate and the near unanimous support of the House of Representatives. This is a uniquely legislative function and responsibility that the Constitution expressly gave to Congress. The last reauthorization was signed into law by President George W. Bush, just as prior reauthorizations had been signed by Presidents Ford, Reagan, and Nixon, in accordance with core nonpartisan American values. After all, as Congress correctly recognized in the hearings held in 2006, racial and language minorities face significant voting discrimination in some parts of our country. Given the successful decisions in the Department's Voting Rights Act cases over the last 18 months, the need for a vital and intact Voting Rights Act remains clear. Last year, a federal court cited the value of the Voting Rights Act in blocking the Texas congressional redistricting map on the grounds that it discriminated against Latino voters. In that case, the court noted that the parties, and now I'm quoting, this is from the court. The court noted that the parties provided more evidence of discriminatory intent than we have space or need to address here. Provided more evidence of discriminatory intent than we have space or need to address here, unquote. The federal court that reviewed South Carolina's photo ID law also noted, and I quote, the vital function that the Voting Rights Act played in prompting the state to change how it will implement the statute in future elections so that it would no longer disproportionately impact black voters. Without the Section 4 coverage formula, neither of these discriminatory voting changes would have been subject to review, and both could have been implemented immediately. These are just two of many examples demonstrating that these problems have not been consigned to history. They continue to exist. Their effects are real. They are of today, not yesterday, and they corrode the foundations of our democracy. Our country has changed for the better since 1965, but the destination that we seek has not yet been reached. Indeed, a reading of today's opinions demonstrates that every member of the Supreme Court agrees with this fact. As the Chief Justice wrote, and I quote again, "Voting discrimination still exists. No one doubts that," unquote. This is why protecting the fundamental right to vote for all Americans will remain one of the Justice Department's highest priorities. The Department of Justice will continue to carefully monitor jurisdictions around the country for voting changes that may hamper voting rights.
Joining us in studio to guide us through the complexities of the Voting Rights Act, as well as the impact of the Supreme Court's recent decision, is Vishal Agraharkar, Counsel at the Brennan Center for Justice. Vishal, thanks for being on the show.
Thank you for having me.
All right, let's go back. All right, it's 1965. What is going on in this country that we need a Voting Rights Act?
Well, a lot was going on in this country. So 1965 was the year that the Voting Rights Act was passed under President Johnson. The reason it was passed is you have to remember that at that time, a number of states in the South were passing law after law that were intended to make it really difficult for African Americans in the South to register to vote and to vote. I mean, these were things like poll taxes and literacy tests, things that we now associate with the Jim Crow era.
And this was a clear intent to do this, by the way. This wasn't by accident.
Of course.
It was clearly preventing people from going to the polls.
Absolutely. These were intended to prevent people from voting.
Well, what did the Voting Rights Act do? What did it do?
Sure. Well, the Voting Rights Act has a number of provisions. The most effective provision, in retrospect, the most effective provision was Section 5. And Section 5 is what was at issue in the recent Supreme Court case. Section 5 basically required certain states that had a history of persistent discrimination in voting to submit any changes to their election or voting practices to the federal government, either to the United States Department of Justice or to a federal court, in order to get that change approved or pre-cleared before it can be put into effect. And the purpose was basically just to make sure that those changes didn't have a discriminatory
And this
effect.
was at every level, at the local level, the municipal, whatever level, you had to send your request to the federal government to review it and have it come back. Fairly burdensome, though, I think, if you consider yourself a municipality or a locality. Am I correct?
Right. Well, I mean, the reason for that is because Congress determined that these states had a history of persistent and ongoing discrimination. You have to remember that at that time, when either a state or a municipality or a locality would put in one restriction and it was successfully challenged, it would just be replaced by something else. So the idea of Section 5 was to make sure that these had to be pre-cleared in advance. But to answer your first question, I mean, it depends on if the jurisdiction was covered. So states that are covered in full, any jurisdiction within that state would have to submit something. And I mean, today, or just before the Supreme Court decision, a number of states are covered in full, but a number of states were also covered partly. And there's also a bailout provision, which allows certain jurisdictions to get out from under the coverage of Section 5 if they could show that they hadn't discriminated in about 10 years.
Okay, 1965, 2013. Clearly, things have changed in society, right? We have an African-American president. Things are a lot different now. What's the problem with changing whether or not these states should have to account to the federal government when 41 other states don't have to do that?
Right. Well, you're absolutely right that things have changed. I mean, we don't see things like poll taxes and literacy tests, but we still see a lot of problems. So in the past 30 years, since 1982, I believe from 1982 to 2006, more than 1,000 changes had been blocked by the Department of Justice and under Section 5 for being discriminatory. As we heard Attorney General Holder say in your clip, just last year we saw some changes, some big changes to voting around the country that were blocked under Section 5. And in fact, in that Texas case, there was a finding by a court of intentional discrimination. So yes, things have changed, but things aren't perfect.
And the other thing is, from what I understand, the court warned that they were going to do this. In other words, I think it might have even been Scalia, I'm not quite sure, about 4 years ago. He said, look, if you don't show us that this is still going on, well, we're going to strike this down. I mean, it was almost like Congress was given the warning. Why not heed the warning? I don't understand.
Well, I wouldn't describe what happened 4 years ago in that case called Namudno as a clear statement that it would be struck down. It was actually very unclear. But you're right that they raised some concerns about the act. But you have to remember, in 2006, Congress did a lot of work. They held more than 20 hearings, put together 15,000 plus pages of evidence that showed that the places that were covered under the act were the places that ought to be covered.
Okay.
Exactly, and they reauthorized it for another 25 years. And they didn't just do so by a thin margin. Actually, the vote in Congress, believe it or not, knowing what we know about this Congress today, was in the Senate 98-0. And in the House of Representatives, it was something like 390-33, and it was signed in law by President Bush. The 4 previous renewals of Section 5, or reauthorizations as they're called, were all signed were all passed with bipartisan majorities and signed into law on each occasion by a Republican president. So there was a lot of support, and that support was there because the law was so effective.
Well, it seems like the major culprits here is Texas, South Carolina, a couple of the other southern states. What are they doing now? Now that they know that the Voting Rights Act is, well, for all intents and purposes, not really valid anymore.
Yeah, so I mean, actually we're seeing a number of states moving forward with discriminatory changes. I mean, just before the ink was even dry on the opinion, I think hours after it was issued, Texas said that its photo ID law would now be in effect. So we're also seeing a number of other states moving forward with new restrictions. And the photo ID law, you have to remember, just last year a federal court had blocked it and said that it was intentionally discriminatory.
We're going to get to those restrictions, but we have to take a quick break. And when we return, we will continue inspecting the nation's polling sites. We'll be right back.
Sir, are you okay?
Everything's fine. Thanks.
You wouldn't ignore this, so why ignore the signs of a stroke? Call 911 immediately, because time lost is brain lost.
Welcome back. I'm your host, David Lesch. Stay up to date with today's verdict by connecting with us and send us in your questions or comments to Facebook or Twitter using hashtag BXNETVER. On today's show, we've been discussing the recent decision made by the Supreme Court that affects voting throughout the country. The Voting Rights Act of 1965 has been, for all intents and purposes, struck down. In studio with us to share his legal expertise on voting rights and more is Vishal Agraharkar, counsel at the Brennan Center for Justice here in New York. Vishal, again, thanks for being here. Let's talk about the Brennan Center. What is the Brennan Center?
Sure. So we're a nonpartisan, nonprofit organization that works on the systems of democracy and justice. In terms of voting, we work to ensure that everyone's right to vote is protected and that elections are free, fair, and accessible for all voters.
And I assume you don't think this is fair, the Voting Rights Act being struck down. So let's talk about what Texas again and South Carolina and some of the other states are doing to take advantage.
Sure. So as I mentioned, in Texas, the photo ID law has been declared to be in effect. Now, that doesn't mean that it's not being challenged, and a number of organizations and voters are going to push forward to challenge the Texas law and other laws under other provisions, under Section 2 of the Voting Rights Act, which is still active, and under the federal constitution and state constitutions. But what's missing is Section 5, which was a critical provision of the Act and one that needs to be restored. So another thing that we're doing is actually advocating for Congress to step in. And Congress, it sounds like there's some appetite there to restore this critical provision.
But it's a big job, though, isn't it, for Congress? They're going to have to get the data that they, in my opinion, were supposed to get 4 years ago. They're going to have to take a look at all the polling sites. It's a lot of work to decide, okay, not the 9 states, but these 7 states need to do. I mean, it's almost like you're reenacting history and going back. It's not 1965, it's 2013. Let's take a look and look at it all over again. Does it seem to you that This is a task that Congress is going to take on?
I think so. I mean, you're right. It seems like it's an uphill battle, but I think that they can do it. I mean, we've already heard positive statements from legislators on both sides of the aisle who are saying that they want to work together to get this done. I mean, it's happened on 4 previous occasions after it was initially passed. And as I said, in 2006, it wasn't that long ago, it was almost unanimous in this. Well, it was unanimous in the Senate with, I guess, 2 abstentions. And so I think that this is just something that's too important to fall on the job for.
You had mentioned about the IDs. I guess you would need to go to the polling site, and now they're saying you need particular IDs. What other shenanigans goes on? Give me another example.
Sure. So, I mean, one of the laws that we're seeing, and you have to remember that there are some state laws, but there are also a lot of local laws. And I would like to point out, and I think a lot of people don't know this, that over the past however many years that Section 5 has been in effect, 85% of the changes that were blocked by the Department of Justice were done to local election changes. So this could be something like moving a polling place, or it could be changing the method of election to make it harder for people's votes to count. They can be very complex and changes, and there could be changes that really go under the radar if it's happening at a school district in rural wherever. So there are all kinds of changes that the Voting Rights Act has been blocking. But right now, to give you an example, in North Carolina, we're seeing a bill moving forward that's eliminating same-day registration. That's also putting in a photo ID, a strict photo ID bill.
What would that entail? Same-day registration. I mean, you can only go on that particular day to register. I don't understand.
Well, so there are all kinds of ways that states make it easier for people to register and to vote. And one of those is that they allow people to vote on the same day that they register. Early voting is another. I think a number of people know about early voting, where in many states allow you to vote before November, the Tuesday in November. And so all these things are being, and we've seen over the past few years that all of these ways in which states have made it easier for people to vote over the years are being cut back.
And there's a method for it. In other words, there's actually the reason for it. I mean, it's to skew an election a certain way, and at least that's what your opinion might be, and that's why we need this. Final thoughts, really, on where we're heading with this, and what, if anything, our country can do, the viewers themselves, to make sure that their voting rights are protected.
Well, they can call on their representatives in Congress to act. I mean, Congress has an opportunity. I think they're having their first hearing in the Senate tomorrow, the first hearing of many, hopefully, and hopefully Congress will act and act soon, because their voting rights are really at risk right now to restore this critical provision in a landmark piece of legislation.
Okay, and Vishal, hopefully in the next 6 months or year you'll come back and we'll see how we did.
I hope so.
All right, well, we have to take a quick break, but coming up, we will review another historic decision made by the Supreme Court and look at how that decision may affect couples when planning for their future. We will be right back.
Nice, Dad. Nice, Dad. Nice. Charles! Nice, Dad.
You don't have to be perfect to be a perfect parent. There are thousands of siblings in foster care who'll take you just as you are.
Hands can do incredible things. Now they can even help save a life with hands-only CPR. If you see an adult suddenly collapse, just call 911, then push hard and fast in the center of the chest until help arrives. Learn more at handsonlycpr.org.
Welcome back. I'm your host, David Lesch. Remember that our show is here to serve you, our viewers. So don't forget to connect with us on Facebook and Twitter and tell us what topics or questions you'd like us to cover on the show. The Supreme Court has had its share of attention with recent decisions impacting 2 acts, the Voting Rights Act and the Defense of Marriage Act. We witnessed as many in the nation celebrated the demise of DOMA as we now can say that marriage has a much broader definition. The decision opens up the door for same-sex couples and gives rights never previously allowed. But that being said, how should these newly wedded couples plan for their future given the implications of the new normal? Joining us in studio to give us some perspective on estate planning is attorney Stephen Pollak from Cooperman, Lester Miller, LLP. Stewart, thanks for being here. It's not just estate planning, it's just tax planning, because with all the good news, there's a lot of things that a same-sex couple who are now married should know regarding their financial rights, correct?
Absolutely.
Let's go with the most important one, really.
One of the basic important aspects that the striking down of DOMA gives same-sex couples is the ability to file federal joint income tax returns, which is very important. A moderate income family that can benefit greatly from filing a joint return.
So we're talking about a marital deduction, right? So let's say, one same-sex partner is making $65,000, and the other partner is making $0. It would certainly benefit them now under the new law, correct?
Absolutely.
Now, why is that?
Because of the way the tax rates are structured between singles and married couples, they're able to have more income at a lower income tax bracket, thereby paying less income tax.
And by the way, we were talking offset. There are certain couples that wouldn't benefit from this, I guess, if you're making a lot of money.
Right. If you're making a lot of money, it's actually a marriage penalty. But I guess with the good comes the bad.
Right.
For
But more often than not, it's going to be a good thing.
Absolutely.
All right, let's keep going. Let's talk a little bit about gift tax. Right? What's a gift tax mean?
Well, both the gift and the estate tax for traditional married couples, there always has been, for at least since 1969, an unlimited marital deduction. So one spouse can pass as much as they want, both by gift or inheritance, to the surviving spouse, no gift or estate tax.
Okay, so for instance, I'm married. Let's say I'm giving my spouse whatever she likes, which I always do, right? Wouldn't I do that? I'm giving cars. I'm giving whatever I want to give. If we were not really married, she would have to pick that up as gift tax, correct?
Not only would there be a gift tax, but the donor is generally the one responsible for the gift tax. So not only are you buying her the new car, but you have to pick up the gift tax.
Okay, now, estate tax. Somebody passes away. What are now the benefits to somebody who is considered to be married when it comes to the federal government?
This was the big Supreme Court case that they just had. The deceased spouse left, as many spouses do, everything to their surviving spouse. The problem was that under DOMA, they didn't recognize, the IRS did not recognize the same-sex marriage. So it did not fall under the unlimited marital deduction, but the IRS said, like you're passing it to anyone else, we'll give you a base limit of exemption, but after that, you're paying a tax. And in this case, there was an estate tax of over $400,000 to be paid.
So that's a lot of money. And if she were married, there wouldn't be that.
Correct.
Give me some other new rights that you would be getting. Give me something else.
Well, employees for the federal government now are allowed to name their same-sex partners, spouses, as a traditional couple would, in terms of pension benefits, in terms of getting you on health insurance for married couples. It's a whole host of things. Pension benefits.
Well, let's talk about pension, because most people, really want to know what's going on with their own pensions and who they make a beneficiary. Before this, DOMA was struck down, and it was a same-sex couple. How would the pension be taxed? How does it work?
Well, while DOMA was on the books, passing a pension or naming your spouse, same-sex spouse, as a beneficiary was the same as naming your child or a third-party stranger as a beneficiary. That the income tax implications to receiving that pension were much more arduous than the benefits are allocated to spouses.
Well, I understood that at the time, before it was struck down, you would still be able to take the pension from somebody who passes away and roll it into your own IRA, but you had to take it at an earlier time.
You had to, right. As a surviving spouses are given the ability to stretch out the ability to take out, whether it's pension money or retirement, IRAs or 401ks, over the course of their lifetime, thereby deferring the income tax for a much longer period of time than a non-spouse.
Non-spouse, because now I understand it's maybe 70 and a half years.
Correct.
And you can wait into that time. Let's talk about some other benefits besides pension benefits. Let's say, I don't know, veteran benefits or military benefits. How does that affect?
Also, you have to remember that while DOMA was on the books, the federal government was not recognizing same-sex marriages. Therefore, they could not name their surviving spouse as a either on their health insurance plans or to receive other governmental benefits.
So what if you were receiving prior? Let's say you were receiving health benefits from your spouse through your employer. You'd have to pick that up as income? Is that what you're really saying?
Part of it is pick it up for income, but the bigger thing is you wouldn't be allowed to be on the health care plan.
To even be on it.
Right.
Well, now that you have these rights as a same-sex partner, now that you're married, do you go and talk to your pension administrator, to your employer? What advice would you give somebody who now has these rights?
There's a list of people you should talk to. You should speak to the pension administrator. You should speak to your accountant. You should speak to your estate planning attorney, because there's a host of other issues that come into play depending upon what your family looks like. Are there children? Like any other spousal arrangement, tax-wise may make sense to have your spouse as the beneficiary. There are also non-tax reasons to have assets go elsewhere.
Well, here's what I'm curious about. I don't know if you can answer the question, but what if you're recognized as married in one state and now you move to another state and they don't have same-sex marriage recognized there? Can you still apply for the federal benefits? You applied the year before. Can you apply now?
It's a good question. A state here in New York that recognizes same-sex marriages, you can get married as a same-sex couple here in New York, and the governor a few years ago back said for New York State purposes, tax-wise, pension-wise, health-wise, we're going to recognize that as a, quote, regular marriage. The question is, if you move to another state, it's kind of an open question. States should recognize a marriage that was validly performed in a state such as here in New York, but there's no guarantee that that's going to happen.
And very quickly, before I get your contact information, because I want it, how far back can you go to recover monies if you wanted to now?
To file amended returns, whether it's an estate tax return or an income tax return, generally you can go back 3 years.
3 years. So you're talking about a 2010, 2011, and 2012 return.
Correct.
Right. Where can we find you?
What? My office is here in the city, 767 3rd Avenue. Okay. Happy to meet with anyone regarding this or myriad of issues that come from this.
Stewart, thanks for coming, and you're going to come back, right?
Absolutely.
That's what I like. Well, that's all for tonight. It's time to deliberate. I'd like to thank both of our guests for joining us, and of course you for watching. Remember, if there's a legal issue or topic you would like to see on the show, email me at davidlesch@bronxnet.org. And until we see you again, always remember, know your rights, know your issues, and reach a verdict. We'll see you next time.
Sure we're not missing anything in the first aid kit.
Yep.
Did you go through the plan with the kids again?
Yes. The more you prepare today, the more you'll be able to reduce the devastating effects of a tornado, an earthquake, a power outage, or any other disaster.